Good morning from New York. I'm Chris Hayes. President Obama officially signed the budget sequester last night, triggering $85 billion in federal spending cuts this fiscal year and $1 trillion in cuts over the next decade. We'll be talking about those cuts on tomorrow's program. And the State Department released a draft environmental assessment yesterday suggesting, wrongly, I'll note, that the Keystone Pipeline would have little impact on climate change. Coming up in a few minutes, I'll be sitting down with Top Chef's Tom Colicchio. I'm really excited about that. But right now, my story of the week, a sordid business. At this week's Supreme Court oral arguments over the fate of Section 5 of the Voting Rights Act, conservative hero Antonin Scalia said something instantly infamous when he referred to the reauthorization of the Voting Rights Act as the perpetuation of racial entitlement. Of course, obliviousness to offensive racial rhetoric is nothing particularly new from the conservative justices on the Roberts Court in oral arguments. But it's not just the way the majority in the Roberts Court talks about race. It's the way they have gone about declaring unconstitutional practices we use to pursue racial equality in a society that is to this day shockingly unequal. The guiding theory of the Roberts Court's jurisprudence on racial discrimination is a belief in colorblindness itself as a guiding constitutional principle, rather than the more substantive goal of actual racial equality. And of course, achieving racial equality has, throughout the country's long, painful, bloody, violent racial history, required constant applications of laws, metrics, and approaches that are acutely race-conscious. You need to analyze the racially disparate effects of, say, a proposed voter ID law in order to make sure you preserve equal access to the ballot. Universities committed to diverse student bodies need to consider the race and ethnicity of their applicants, and school districts committed to integration need to monitor and track the racial makeup of their student body. The Roberts Court's conservative justices have no patience for any of this. In his dissent from a 2006 Texas voting rights case, Roberts famously proclaimed that he found the government's intensive involvement in achieving a racial equality in redistricting an icky affair. It is a sordid business, he wrote, this divvying us up by race. And a year later, when the court struck down two school districts' broadly popular integration plans, Roberts declared his rationale with the fatuous declaration that the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. That sentence, I think, is a perfect distillation of Roberts' jurisprudence on race, with all of its appealing pseudo-simplicity, its adolescent sophistry. It's a very short distance from the logic of that reasoning to asking why there isn't a White History Month. The Roberts prescription of colorblindness, of course, requires the court, politicians, and citizens to simply ignore or forget the actual history of actual places and peoples and institutions and laws and traditions and cultures, the lived experience of human beings embedded in a real existing society where cutesy Cohen-like proclamations fail to reckon with the awesome breadth and depth of the fact of slavery, Jim Crow, and their twin legacies. And never was this more apparent than the actual voting rights case before the court this week, where the conservative justices wanted to talk about the abstract principles of federalism while almost entirely ignoring the actual record, the 15,000 pages of documentation Congress assembled during its reauthorization hearings, and the raft of restrictive voting laws still being passed, and in some cases struck down, in the states covered under Section 5. It was left to Justice Sonia Sotomayor to raise the inconvenient fact that the actual plaintiff in the case, Shelby County, Alabama, wasn't exactly a model of racial enlightenment, since the city of Calera redistricted its lone black city council member out of the seat in 2008. And that was just one of many such instances.
Assuming I accept your premise, and there's some question about that some portions of the South have changed, your county pretty much hasn't. In the period we're talking about, it has many more 240 discriminatory voting laws that were blocked by Section 5 objections. And why would we vote in favor of a county whose record is the epitome of what caused the passage of this law to start with?
That moment in oral arguments reminded me of the moment on our show last week when we were discussing and debating the Voting Rights Act. Bishop Harry Jones interjected to respond to Horace Cooper, who had argued that Section 5 of the Voting Rights Act was outdated, to say this.
I would challenge him to come to Alabama and run for office and see if he could win. And I think that one of the things that we have to also look at the fact is that Section 5 has been the one thing that has leveled the playing field.
Before the Supreme Court heard oral arguments in Shelby v. Holder, John Lewis, a man who has lived the history of the struggle for voting rights as much as anyone, spoke on the steps outside on behalf of the history that roughly 1 hour later Roberts and Scalia seemed only too happy to erase.
There are still forces in this country that want to take us back to another period but we're not going back. We've come too far. We made too much progress to go back. The literacy test may be gone, but people are using other means, other tactics and techniques.
Right now, this morning, that same John Lewis is in Selma, Alabama, commemorating the 48th anniversary of the Selma-Montgomery March. And I have to say, the country would be a lot better off if Roberts and Scalia were down there with him. Joining me right now, we have Linda Greenhouse, a Knight Distinguished Journalist in Residence, Joseph Goldstein Lecturer in Law at Yale Law School, who covered the Supreme Court for the New York Times for 30 years and now writes an opinion column for the Times website. Dale Ho, an attorney with the NAACP Legal Defense and Education Fund and a member of the litigation team for the defense in Shelby County v. Holder. Judith Browne Dianis, attorney and co-director of the civil rights group The Advancement Project, and friend of the show, Akhil Reed Amar, author of America's Unwritten Constitution, The Precedents and Principles We Live By, Sterling Professor of Law and Political Science at Yale University. Great to have you all here.
Thanks.
So, oral arguments this week. We talked about the case last week. I'm curious. I think a lot of people went in essentially anticipating a tremendous amount of hostility towards Section 5 on the part of the conservative justices, and they were not disappointed. So I guess I'm starting. My first question, and Dale, you worked on the litigation team. What were the surprises in oral arguments to you?
Well, we weren't surprised, as you said, that there were some questions raised about the continuing need for Section 5 of the Voting Rights Act. In fact, if anything, I think people were a little less hostile than maybe they were 4 years ago in the Northwest Austin case when some of the same issues came up. What was, I think, really, really interesting right out of the gate were some questions by Justice Sotomayor about how a plaintiff county in the state of Alabama, of all places, can be the kind of place to, with a straight face, come before the court and say we no longer need the Voting Rights Act, given the record of discrimination in a place like Alabama.
If I could say about that, and I think this has sort of been lost in the discussion of the case. So Shelby County, Alabama didn't wake up one fine Sunday morning and say, let's challenge the Voting Rights Act. It was recruited. Yes. It was recruited by this one-person Project on Fair Representation, backed by lots of right-wing foundation money, to go out and accept the court's invitation from 4 years ago in the Northwest Austin case to bring us a better case. Because this is the playing out of what I've called the Roberts Project. Last year in the healthcare case, I had predicted that the Chief Justice would ultimately vote to uphold the Affordable Care Act. Why? Well, various reasons, but basically, I didn't think he was animated by the sort of anti-federal government animus that led to so much of the criticism of the ACA. But I do think he's animated by, as you said at the top of the show, this colorblind notion, and to get the government out of the business of counting by race, and that's what motivates him, and that's what this case is about.
Racial entitlements. Shocker.
You're talking about Anderson Scalia's line.
Yes.
Let me play that just so that everyone can hear it in its context. And what's very interesting about the context is when I first heard it, that was the kind of pull quote of the oral arguments. And I think it's actually worse in context. Because basically what he's saying in context, he's making the argument that the reason that this is that you need tremendous judicial activism to strike down, what Congress has passed under 21 hearings, 15,000-page record, is actually because the democratic process has this fatal flaw, which is that it cannot liberate itself from the straitjacket of political correctness that is racial entitlement, That if you call a law the Voting Rights Act, that every legislator just bows before that, and that means that there's this kind of role for the courts because the democratic process is so fallen and dysfunctional that they just keep unthinkingly passing this. Take a listen to Justice Scalia.
I think it is very likely attributable to a phenomenon that is called perpetuation of racial entitlement. It's been written about whenever a society adopts racial entitlements, it is very difficult to get out of them through the normal political processes. I don't think there is anything to be gained by any senator to vote against continuation of this act. And I am fairly confident it will be reenacted in perpetuity unless a court can say it does not comport with the Constitution.
I love the line in there, it's been written about, the sort of citation, like written about where Newsmax and Town Hall have been writing about the fact that racial entitlement binds people forever. I want to get your reaction to that quote, and I also want to bring in one of the individuals who argued before the court, who is live in Selma, and we have a little bit of news from a retired Republican senator who thinks the court should butt out. All that after this break.